Mr. Gale. Sorry, I'm Mr. Muir. I beg your pardon, Mr. Gale. Mr. Muir, you've got further submissions to make, I'm sure.
I think, my lords, my lady, just before lunch I was in the case of Spirose. There were just one or two other remaining parts of that I ought just to pick up as we're at that tab, which is number 13 in the authorities bundle. And having looked at Lord Scott, I should mention within the judgment of Lord Collins of Makesbury, there's reference on page 1819, 1819, paragraph 72, to the modern basis of valuation as represented in what I gather is one of the accepted textbooks, extracts of which the court has at tab 15. I won't go to them in detail, but there's mention of this at paragraph 72, dealing specifically with hope value, and as it's put in the second sentence of the quotation, as the hope crystallizes into reasonable certainty of a permission at some stage, evaluation can be attempted based on the potential development value deferred for the anticipated period until permission will be forthcoming, but with some end deduction to reflect the lack of certainty. And all I would mention, my lords, my lady, is that really is what is done by the valuer in section 5 of his report, at pages 90.
Nobody's disputing, as I understand it now, Mr. Muir. It's just a question whether this is a relevant factor, isn't it?
Well, perhaps the last point that I can take, therefore, from the case itself is at paragraph 92, and this is again in Lord Collins' judgment, where it simply makes the point that one plainly relevant element in the value is the prospect of exploiting the property, and there's reference to Cripps at paragraph 93. When lands used for agriculture are suitable for building purposes, this is necessarily an important element in their value. This is at the top of page 1823.
And why did the House go into such detail? Was it because they were trying to construe a section in the statute?
Yes.
What was meant by section 5.2 of the 1961?
Yes, and they were looking at the principles of valuation to understand.
Luckily, they didn't have clause 18.2, which we're going to.
Well, no, they did not. But perhaps the sentence I reached is of interest because it makes the point that when land used for agriculture is suitable for building purposes, this is necessarily an important element in their value and a matter for which the
It's all about.
It's not the only matter.
All this is entirely accepted. It's all about what clause 18.2 means.
Yes. Well, in that case, perhaps I can put aside the authorities and turn back to the lease. Before I reach 18.2, which must be my destination, there are just one or two points which I think I need to emphasise in the earlier provisions of the lease. Yeah. The court has been taken to the first clause, which defines the subjects as all and whole an area of ground at East Waterhead Farm. Those are the subjects of let. The reference in the rent review provision at clause 5, as I think has already been pointed out, refers partway down clause 5 to assessing rent on the basis of an open market rent, and no account should be taken of works effected by the tenants or on their behalf, and that's an instruction to the arbiter dealing with the rent review mechanism.
You're not suggesting, are you, we get any help from that?
Other than the reference to the open market again, which is what's followed up in 18. The key point, perhaps, that I can take from the earlier provisions is just to revisit clause 9, if I may.
What is the open market rent here? How does it help you, Mr. Muir?
I'm merely saying that the rent review begins with a rent which is specified for the first year, and we've seen that it steps up until after the 5th anniversary. But thereafter, it's an open market rent, and of course that will be for whatever is on the land at the time, and that chimes in with what clause 9 reminds us, which is simply that the tenant can ask the landlord to use the property for some other use, and when one's dealing with what the obligations of the tenant are under this lease, it's important to bear in mind that parties anticipated the possibility the possibility that the tenant would seek and obtain consent.
I mean, you wouldn't charge rent, would you, on the basis of, for example, you might use it for residential housing? You wouldn't charge an open market. No. So what do you get out of open market rent in clause 9, clause 5? And what is it open market rent for?
Well, that would be an open market rent for the property as it is at that time.
But, and this is quite significant in view of the contrast with the other clause, no account should be taken of works affected by the tenants. So that if they put up residential property, houses and so on, no account would be taken of that.
That would obviously depend upon the consent of the landlord having been given to that.
Of course. But no account should be taken of works affected by the tenant. So they're left out of account by the valuer.
Yes.
And all he's left with, one would have thought, is the agricultural land suitable for development.
Well, it depends. It rather depends on what the use is. Because if he's yes. I think it needs to be read with clause 9 about occupation and use, because that's the clause that begins with the obligation to occupy and use the subjects for the development of a pay and play golf course and ancillary activities incidental thereto, and for no other purpose whatsoever without the prior express written consent of the landlords. So up to that point we know that it's to be a golf course, but there's a possibility of other use. And then the clause continues, if the golf course is not developed within 5 years of the date of entry, or if the subjects of let cease to be used for the foregoing purpose, then this lease will terminate with immediate effect. Now the foregoing purpose there, in my submission, has to be whatever the purpose that's consented. Begins as golf course use. But plainly, if the tenant asks and the landlord agrees to a change to something else, then the obligation on the tenant is to use the subjects for that purpose, not to go off on some other use. But my lords, my lady, that I think reminds us that the options clause may operate at a time when the obligation of the tenant is not to use this as a golf course, but simply to use it for whatever it is that he has been consented, he has been allowed to use the subjects for by the landlord under clause 9. For example, if the tenant develops the golf course, trades for a few years, finds he's losing money, decides that it would be more profitable to him to use it as agricultural land or something else, then it's in his power to ask the landlord for a change. And if the landlord consents to that, then his obligation is to use it for that changed purpose.
And what's that got to do with the point we're on?
Well, the option has to operate throughout the period of the 50 years of the lease, at times when the obligation of the tenant may be to use it for one use that is not a golf course. And it seemed to me respectfully that some of the discussion this morning was highly focused upon golf course use, and I accept that is the point of departure for this lease, but it's not necessarily where the parties will end up during the currency of the lease. So an assumption, for example, that the tenant is fulfilling his obligations may be an assumption that the tenant is using the property for the purpose which the landlord has consented under clause 9.
Well, I'm not sure how that helps us when we're told that the base value, as one might put it, is of agricultural land or open space suitable for development. I mean, supposing the land is not being used now as an enormous complex for paintball games and so on, and
Yes.
golf has simply disappeared. Nevertheless, the valuer has got to look at it on the assumption, hasn't he, that this is agricultural land or open space suitable for development.
Yes, that's the state of the land as my learned friend described it. And I don't think that there's a difference between the parties about that. That's the point of departure for the valuer. But I'm making this point simply because there was some discussion about the nature of the assumption. And I should say, my lords, my lady, that the assumptions and the disregards from the respondent's point of view are, in a sense, not crucial to the question of whether the development value has been stripped out. It may be where one would expect to find a disregard of development value, although it is not there. But the operation of the assumptions and disregards was not something which was attacked in the courts below.
No, but that's what makes the whole approach in the courts below seem so, in a house, seem so unrealistic. And frankly, I mean, I find the idea that you disregard the last part of the clause very puzzling. I mean, I can see how one might fit it in on your approach as well as on their approach. Yes. But I mean, it's very bewildering to me how no account has been taken by the inner house of these last words.
Well, I don't say that one ignores them. What I say is that those assumptions and disregards do not contain the stripping away of the development value. And therefore, the appellants have to find the stripping away. In the earlier words, the genitive clause, upon which we were addressed the court was addressed this morning.
But how do you reconcile them with the interpretation that you seem to favour of the phrase of agricultural land or open space suitable for development?
Well, firstly, there is the point which my lord in the chair made this morning about whether the suitability attaches both to the agricultural land and to the open space. I think with respect, I'm perhaps open-minded about that. It's not a point that was explored below, but one can understand that agricultural land is a specified type of land, of use of land, which a valuer can latch onto. Open space may require something more to explain how it's to be valued, and so the suitability might only attach to that. But that I don't think affects the position for the. Other than that, it doesn't affect the position for the respondents. In my submission, one begins with the clear direction to ascertain full market value of the subjects hereby let. And that, of course, is the beginning of the.
Yes, and then you miss it all down. Then, in determining the full market value, then it tells you what you're to do.
Yes.
Now, you can't ignore that, can you?
I don't say that one ignores that, my lord. No.
Right, so does one take account, therefore, of what's been built on the land, what's been done, the works which have been done?
Well, in the courts below, and this was a matter of agreement, and I accept that there's
I'm asking what your position is, Mr. Muir.
My position, my lords, my primary position is simply that the description of the land as being agricultural land or open space suitable for development as a golf course is telling the valuer what type of land he is to value.
How do you square that with the last part?
As far as the assumptions go, the valuer is. These are, of course, simply assumptions. And the point is that the valuer is not having to. The valuer is not having to decide other than what the tenant is obliged to do. I've made the point that may or may not be related to a golf course. At the moment, in this case, plainly it is.
But I mean, if after 5 years, you would surely say, if you were landlords, you would say, well, you should have built the golf course, and if you had, we would have been entitled to the value of the land with the golf course, and that's what the assumption is.
Indeed, and the law goes further because the tenant is only entitled to purchase if his obligations have been I think that's in.
Yes, of course.
That's in clause.
Well, I mean, if he hasn't done it within 5 years, the things come to an end.
Clause 18.3. But the point about the.
Well, I was wondering if, just to pursue this a little further, if we look at the top of page 88 in the appendix, we see the way the valuer, no doubt with advice, is approaching this part of the option clause. And he says the wording of the option ensures that a capital expenditure incurred by the tenants is disregarded. And I don't follow that, I must say. If you're asked to assume that the subjects are in good and substantial order and repair and that all obligations have been complied with, one would assume that capital expenditure has been incurred. In year 6, let us say, you've got an up and running pay and play golf course, which involves capital expenditure, and you're then making that assumption in striking the full market value. So you've got an asset which is fully developed, with that expenditure. Why do they say you disregard it?
The valuer has proceeded on that basis because of the words earlier in the clause, which are the words of agricultural land or open space suitable for development.
Was he instructed to do that?
That was his understanding after discussion, as I read the valuation.
So he is disregarding the assumption. He must be so.
And he's disregarding also what it said, that landlords shall disregard otherwise than in pursuance of an obligation of landlords.
Well, that with respect gives an issue as to what the proper valuation of land without reference to the hope value would be. Because if you simply forget the hope value for a moment, there are two ways of approaching the valuation without it. One is to assume that the tenant has fulfilled his obligations, built the golf course, and one is to take the view that the description of the land, the state of the land as it's described in the statement of case, is agricultural land or open space suitable for development, so that it's stripped out. Now, in the courts below, the council, these respondents, made the submission that the purpose of dealing with the state of the land in that way was to prevent the tenant from having to pay twice.
It's inconsistent with what it says. I mean, one bit of the clause which actually you can understand is the bit from in determining the full market value onwards. I mean, that bit one can actually understand.
Yes. The question, what I suppose I say is that the assumptions and the disregards begin with the phrase in determining the full market value.
Yes.
So at that point, these provisions thereafter are focusing upon full market value. They're not assisting
subject to the assumptions, because the valuation has to be undertaken on those assumptions.
Yes. But they're not telling us full market value.
So it would be a different one. It would be a different, quotes, full market value without the assumption.
Yes.
Or at any rate, potentially.
But these are how you determine the full market value. It doesn't tell you of what. It's
Well, I would have thought it did. It's saying exactly that. It's saying that the subjects hereby let are in good repair and so on, and all obligations have been complied with. So you look back to see what the obligations are, and you've got clause 5 and so on that tell you what's expected to be done. The drainage is all there, and so on and so forth. I mean, this is an important point, because if we're persuaded that we should allow the appeal, then it goes back for evaluation anew on the basis of such construction, all as ordained by the Lord Ordinary. Now, the Lord Ordinary, I think, has said that you have to have regard to these. And Mr. Gale doesn't accept that.
And if it goes back, what that means, what that would mean is that one would be looking at it with the golf course there.
I'm sorry, looking at it?
With the golf course there.
Yes.
I don't quite understand why you've sort of pinned yourself into this extraordinary bit, because, I mean, as I understand your position, you could have a huge golf course there, but if the hope value was much higher, you would say you would get that, so it wouldn't matter about this, you would leave this aside.
Well, Lord, I'm not intending to pin myself to it, and if I've done that, then it's my mistake. But that was the approach which has been taken hitherto, that the sense of the earlier words, and it may have been a matter of agreement below, but that says nothing here. That the approach of the earlier words of agricultural land and open space suitable for development was describing the state of the land that the valuer was to look at. Now, I quite accept that if development value is simply not included, it becomes highly germane to know whether the valuer is to look at this land with a golf course or without a golf course. I entirely accept that, and I accept that the valuer would benefit from advice about that.
And will he be bound to have regard to the fact of the golf course? Wouldn't he? If there were no development problem, the valuer would be bound to value it on the basis, value the land on the basis that the golf course existed.
Yes, and he'd be looking at it, exactly. He'd be looking at it in that character. And I think to be fair, there's a point which Lord Dyson made earlier, which was that the assumptions concerning the golf course and what might have been done about that may become of very little importance in monetary terms if one is looking at development value. and therefore one can perhaps understand why, including development value...
Well, they appear to be irrelevant, certainly on the approach of your valuer.
Yes.
And so what's troubling me about the clause is that on that basis, how does the clause operate? Because it's very extraordinary that there's an obligation that he shall assume that in determining the full market value, he shall make those assumptions, if on your construction, they're irrelevant.
But it depends upon what that development value is and the parties.
Well, doesn't it tell one that at the date when this was drafted, there being no current proposal for residential property or anything else on this land, the framer was simply assuming that all that was going to happen here was development of the land as a golf course or some other suitable development on what was previously agricultural land. And it wasn't really contemplating the sort of development value that is now in prospect. And it's a clause which can operate at various stages in the history. I mean,
exactly.
in year 2, when you don't have the fixed price, you can look to see what the state of affairs is, and maybe a certain amount has been expended. There wouldn't be a full up and running golf course, but you can look at it as in its current state. In year 7, there would be a fully developed golf course,
yes.
And one would apply the assumptions which would seem to suggest that at that stage it's not a place that's suitable for development as a golf course. It's actually a golf course that has been developed because the obligations have been performed, and you look at it on the assumption that that has happened.
Well,
and that would seem to make some sort of commercial sense, that the landlord, who's after all surrendering ownership, will say, well, you've developed this, but if I was to sell this, if I was free to sell, I would get a price which would recognise the value of the land now with an up and running golf course. And if you want to take it away from me, you must pay the price that I would be able to obtain in the open market too.
yes, but the question of this lease is whether over the 50 years that it endures, parties at the beginning have agreed to strip out any alternative uses and potentials that the land may have. And the position of the respondents is that given the factual circumstances to which I drew attention before lunch, and the fact that development plans do vary over time, and that there is no restriction upon the use to which the land can be put after the purchase takes place, that the parties did not intend, by the mere reference to suitability in the preamble to this price provision, did not, either in plain terms or by intention, intend to strip out the possibility that this may be used for various other purposes, particularly against the background, as I've mentioned, that the tenant may indeed be using it for something different from a golf course at the time that the option is exercised.
Or for something as well as a golf course.
Or for something that
perhaps
I
more
would like,
likely.
yes.
Although if he is, those have to be disregarded, don't they?
Yes.
Under the second part of the clause, little 2a.
Mm-hmm.
So
Unless we read clause 9 as saying that he's obliged to do the things that the landlord lets him do that aren't a golf course. It's quite clear he's obliged to do a golf course. It's not so apparent, as indeed my lord was drawing attention to this morning, that he's obliged to do the alternative uses which the landlord might permit.
and let's suppose he does something which he hasn't got consent for. Then what? The landlord shall disregard any improvements, it says.
Well, the lease is terminated, so he doesn't have the option.
Yes. Yes.
Well, is that right?
Well,
Yes,
sure
under clause
that
9.
yes.
Well, no, I'm assuming that he doesn't ask for any more. He just does something
Yes, he does
extra.
it. Well,
It must be authorised improvements, mustn't it?
yeah.
Yes, they would need to be authorised, and the point, yes, and the point may be that such improvements would indeed be within an obligation of the tenants because he's
Well,
consented.
that's your view, but it's not crystal clear on
Yes, I
clause
mean,
9.
they could under 10, they could remove the, they couldn't, to rectify a breach, so they could do that.
Yes.
They could do that.
And just talking about use in 9, and I suppose things could be put up that fall somewhat short of use.
Of use. Yes, that would depend on what was being put up. But in principle, one is looking at, as I said before lunch, one is looking at a market, and the question is, what tells us that this market has to be restricted in this way,
The
other than the word?
The answer is the assumption, or not. As the case back follow, you say it doesn't tell you that.
Yes.
But on your analysis, in the kind of factual situation we have now, which you say would have been or should have been within, at least in the contemplation of the parties, you are construing the clause in circumstances where, in determining the full market value, the landlords have no need to make the assumptions which the clause says they must make, because they're wholly irrelevant.
Well, I think there are 2 points I'd make about that. First is that the parties have committed themselves to a contract which requires the valuation to be struck at the date of entry on the purchase. That may be 40 or 50 years after 45 years after the lease is entered into. And of course, it's up to the tenant to decide whether, and if so when, to exercise this option. And it's perhaps of interest that the option here is exercised after the structure plan introduces the potential, and just before the local plan provides the substance to that. But it's up to the tenant when and whether he does that. And of course, the key point about the assumptions and disregards is that if there was a specific word or expression that was intended to strip out the value, that I think, with respect, is where I would look to find it. One would look for a disregard of
or an assumption,
or an assumption dealing precisely with that point. And as we've seen from the other cases, there are words and expressions which can be used, whether it's solely or for no other purpose or existing.
There are lots of different ways one can construe any contract law.
Well, indeed, and that is what one would expect to strip it out, and that is not what we find in the assumptions or in the disregards. Now, what that means in terms of the sense of the provision is, in my submission, this: that the tenant has a choice as to when and whether he uses it. He struck it at a particular time here, but if the appellants are right, then a windfall to them could operate in very considerable financial terms at almost any point in the lease. They could, as has been said, do very little in the first 5 years, but against the changing development plan, it may be that they would then get planning permission and be able to purchase on their argument simply agricultural land, open space, suitable with an assumption that certain obligations during those early years have been done.
You may have already made this point, and if so, please forgive me, but can you just tell me in very simple terms what purpose do you say is being served by those words of agricultural land or open space suitable for development as a golf course? What are they doing there?
Well, at most, they are there to advise the valuer to approach the land on the basis that it is agricultural land or open space suitable for development as a golf course. And that is the characterization of the land which are the subjects of let. It's a physical description of land. It's not dealing with whether obligations under contract have been adhered to or not. It is a description, as I read it, of land.
Well, we've got there because that's what the subjects are. That's
those
exactly what
words
the
aren't
subjects
needed,
are.
they?
I mean, he goes on to it and sees a golf course. And does he suddenly say, well, this is agricultural land, suitable for development of a golf course? He's standing on a golf course.
Yes.
What do these words do in that situation?
As I say,
Can't describe it. You couldn't give the physical description of the subjects because it would actually be a golf course. It wouldn't be agricultural.
that is what if they have a meaning, and one wishes to ascribe a meaning to words, if at all possible, in my submission, that is what they are doing. What they are not doing, plainly, in my submission, is that they are not stripping everything out, because that is not the words that are used, and suitability.
The question is whether you've stripped it in.
Well, in my submission, the concept of market and full market is...
But that depends on the assumptions, as all the cases say that.
Well, indeed. But we look in vain in the assumptions and the disregards for something that takes this out.
That's the question.
I suspect that the value would say those words to which your attention has been drawn will direct him to the comparables that he's looking when he works on the comparative principle to decide where he's getting his figure of value from. I mean, he'll look at transactions, no doubt,
yes,
where agricultural land or open space suitable for the development of golf courses is in the market. And he'll be able to say, well, there's a series of figures I can look at for comparison purposes, and there are various reasons why the figures I'm given with are either too high or too low for what I've been given here. So that's a fairly standard exercise, I would have thought. And I don't have a difficulty with that until we get to the assumptions, because I would have thought that one could build in the idea of full market value as you've been putting it, because you'll see some figures that are very big for agricultural land, and you would ask yourself, why is that attracting such a high price? Oh, because the local plan has a zoning for residential purposes, and that would explain itself. But the assumptions are because they've been brought in perhaps from some other kind of document dealing with other kinds of subjects, and somehow one has to fit them in. And I still don't really understand what your position is about that.
Well, the assumptions I accept are there for that purpose, and they relate to the market value. The first assumption, which are that they're in good and substantial repair, we understand that, I think, that all obligations of the landlords and tenants under the lease have been complied with. That, again, depending upon the particulars, may require use as something else. In the present case, they require that the subjects be used only as a golf course. So there's no question of payment for failure to fulfil certain obligations to keep neat and tidy or something like that. He's not looking behind the parties' relationships to look for things which have not been done by either party on either side, and throwing that into a financial calculation, reducing the price because the tenants have failed to do this, or increasing them because the landlords have failed to do that.
What does assumption 1b mean? That the subject's hereby letter ready for occupation. For occupation for what? For occupation for development, or for occupation as a completed golf course?
Simply for occupation, that they are ready. Nothing has to be done to them.
Means as a golf course, that's what it means, on the true construction of the lease, absent any variation of it.
Well,
that's what I suggest it means. The subject's hereby letter ready for occupation. I mean, the whole assumption these assumptions are written in on the assumption. The whole point is that the tenant is assumed to have discharged all his obligations under the lease. And at any rate, after 5 years, in this case, that means the whole shooting match is up and running.
Yes.
That's what it means. And it's got to be, therefore, after 5 years at any rate, premises got to be ready for occupation. And that means ready for occupation as a golf course, surely.
Well,
I think it means ready for occupation. It's a sort of hypothesis, and that would be the case even if it was before the 5 years. But since this is after 5 years, that doesn't really matter. But after 5 years, that was the assumption. And I think your difficulty in this part of the case, as I pointed out before, is that all of that is really irrelevant hypothesis once you have regard to the development prospects of the land, as we see from the valuation here.
But of course that depends upon what the zoning is for. I mean, for housing development, that may or may not be the case. But what if it was zoned for something else, which had a marginal difference in value for the valuer? And we're looking at it from the point of view of somebody looking at housing development value. But of course, there may be a variety of other values which can be placed upon something according to the use offered in the structure plan.
It's a very odd assumption, because the subjects are actually ready for occupation, because the tenant is occupying them.
Yes, and indeed all of these assumptions and disregards, in a sense, are looking at as much at the past history of the subjects in the relationship of tenant and landlord, and they're not looking to the future They're not necessarily prospective and looking at what's going to happen in the future.
Surely, once you depart from your primary position of saying open market, full market value means including all hope value, whatever that might be. If you depart from that, as you seem to be a moment ago, by acknowledging there might be a difficulty where, in the case, say, of residential development, then you're surely in an impossible position, because you're then having to find some meaning for full market value, which did strip out hope value for some purposes, or in some respects, but not in others. And I just don't see how you can possibly get that out of the language of the clause.
I'm not saying, my fault, I'm not saying that one strips it out for some purposes and not for others.
And I thought you were acknowledging that it might be difficult for you if the hope value, as it were, unconstrained by the clause, were to reflect the possibility of a complete residential development of the site, so that on which basis, as has been pointed out to you, the assumption simply doesn't work. But I thought you were postulating a possible halfway house of some development which was for something different from a golf course, but nevertheless could give some scope for the application of the assumption.
I'm simply reminding us of the fact that the development plan might have zoned this for something else than residential value, and that the monetary consequence of hope value might differ according to whether it's hope for residential value or hope for commercial property or hope for allotments or other things according to the zoning. So the fact that in monetary terms the assumptions about performance of tenants' obligations may seem minimal in comparison with a housing development doesn't tell us that it's going to be minimal in comparison with some other zoning for development.
I mean, what strikes me as the strength of your case is really the more commercial point that one can't help suspecting that the parties never really thought about this. You may say that, anyway, it rather looks as if nobody ever really thought about it, because one can't help thinking that the contract might have been in slightly different terms if they had. Yeah. But if they had thought about it, nobody would have entered into this agreement, because the idea, at least both parties, would never have entered into this agreement, because the idea that the tenant should obtain the kind of windfall which the appellants will obtain if they're right would be really quite out of the question. The parties would never have agreed that consensually. And the contract, unless the position is absolutely plain under the contract should be construed on with that in mind. Yes. See Lord Diplock in the Antilles, for example. I mean, it seems to me that is quite a compelling.
Well, I was coming to your point of view. Indeed, my lord, I'm obliged. And I was trying to come to the question of commercial reasonableness and sort of fair and reasonable commercial construction, common sense, and so forth. And in my submission, there is really no common sense in a local authority which has this land in public ownership, entering into a contract which enables it to be taken in this way almost immediately. When it's so close to a town centre, and plainly a 50-year period is allowed for, and the windfall here would be considerable for the tenant. The option, of course, not tying him for any future use of the land.
This was not designated green belt or anything.
No.
Because I mean, you can have land near towns designated green belt. The one thing you're not meant to, there you wouldn't necessarily assume that people, you might say, well, absolutely not. I'm afraid, that's the one thing it's not going to be.
Yes.
You say this is not green belt, so that problem doesn't exist.
But I mean, it's my submission that really that's where some of the cases about what might be expected to fulfil the function here of stripping out this attribute of the land are helpful, because they do remind us that one would expect, when one's dealing with concepts of market and full market, one would expect to see some clarity if that sort of value, which is inherent in approaches to land valuation in this country, if that element of the value was to be stripped out. And whatever else the reference to suitability for one particular use does, my submission, it does not, as I said before lunch, tell you that it's only ever going to be used for that, or it's unsuitable for any other purpose. So the introduction by the Lord Ordinary of the word solely is an interpolation. The question is whether it's justified on the reading of the lease as a whole. The interpolation in the appellant's statement of case of the expression "for no other purpose" is again an interpolation of words that are not there. Is it justified?
I'm sorry.
Sorry.
No, I was just wondering, going back to the commercial reality point. I mean, it is a fact, striking fact, that the parties did agree a fixed figure of £130,000 for the first year.
Yes, exactly.
And that surely is rather striking. That, I think one can reasonably assume that didn't reflect any hope value for massive residential development. So at any rate, in year one, the local authority was prepared to agree this fixed figure. And it isn't impossible that towards the end of year one, that the planning situation would have changed.
I accept that it's of interest. Of course, the fact is that in 1999, the landlords who owned the property at the time, they still own it, the council, would have been aware, no doubt, as others, of where the development plan process stood. And it's not until some 7 years later that any of the community growth area come into the structure plan. So it's not impossible that no one's mind was pointing to that at that stage.
I just wonder how, it's all very well to talk about adopting a commercial approach, and that, of course, is what should, in an ideal world, be adopted. But we all know about local authorities, indeed governments. They are notorious for not being particularly commercial. Now, I just wonder how important a point this is when we are trying to ascertain the meaning of the language, and how much, if you like, a commercially undesirable result should be something that can permit a court to adopt a somewhat perhaps strained interpretation of the language that's been used.
Well, my position on that is that I've mentioned all the factual background, I won't repeat them, but we're looking at market value to be struck at the point of the purchase. And therefore, parties were accepting at the beginning that the date at which you look at this market is at the date of the option being exercised. And parties will no doubt have been aware that land use changes, particularly close to town centres. I'm not sure, therefore, that one necessarily has to strain the approach to the word suitability, suitable for, in the present case.
I'm not sure that really meets Sir John's point. I mean, the figure, one only has to look at it to imagine that there wasn't any element of hope value of the kind we're talking about now.
Yes.
At all. The problem is we don't, because evidence hasn't been led in this case, we don't have any background information as to the state of affairs when the lease was entered into. So there's a bit of speculation as to what the state of affairs was. You're not in a position, you certainly don't aver, that at the time it was entered into there was absolutely no question of it ever being used for anything other than agricultural land or development as a golf course.
No, but there is no evidence either way on that.
There's a curious development at page 21, Common Sense, Article 3 of the Common Sense. Prior to the pursuers taking entry, the subjects had been in use as a pay-to-play golf course.
Good. Prior to?
Yeah.
Goodness.
Where's this?
It's page 21 of the appendix. They took entry prior to taking entry.
Indeed, Lord, I think the person originally responsible for that pleading is not I suspect here, but it's not an averment that's admitted by the council.
No, it's not.
And it's and
You just say they've been used as a golf course since the pursuers took entry.
yes, and my
It
understanding.
sounds as though, does that mean that they were actually operating as a golf course as from entry?
No, my understanding is that the grazing came to an end at the 31st of May. Entry was taken on the 1st of June, and works began
Yes,
very
after that.
promptly after that. with the lease being executed in early 2000. So that's certainly.
So it's just a rather slack about it.
Indeed, I understand.
Could I just ask you something that may be impermissible to ask you, and you'll tell me if it is. But I understood from Mr. Gale that it was common ground that if the appeal fails, the option fails and can't be exercised again. That means that if the appeal fails, the council is not going to get this money. It's stuck with 39 years more of lease. Is that correct?
That is the position, my lady.
Yes. So the position is that the council's, if the appeal succeeds, well then the council gets some money and the tenant gets a windfall. If the appeal fails, the council is stuck with a golf course for the next 39 years.
Well, my lady uses the word stuck with. I'm not sure that's...
In other words, you'll go away and settle it, won't you?
Sounds like agreement, yeah.
Is that the reality of the matter?
Well, it is a matter of agreement that the option falls in the way that
Yes.
my lady describes.
Yeah, I see.
That's correct. Now, my lords, my lady, as far as the rest of the submission goes for the council, I'm not sure there's a great deal more that can be said about the failure to articulate the stripping out of the development value. The question of the specific words which say suitable for development as a golf course, in my submission, simply don't come up to what would be required to do that in the context of this provision.
You can't give them any very sensible meaning at all,
Well, the meaning...
consistent with the last part of the clause.
Well, the meaning of it is to direct the valuer to the type of land which he is to value. That is...
You send somebody along to value a golf course, as it happens to be. You tell them to look at it as agricultural land. Seems very peculiar to me.
Well, that's how the valuer has done it. And if that's error, then that is error. But that is how it has been done. And the only dispute about the valuer's approach is not that he's gone and looked at it as agricultural land. The dispute between the parties is that he has included within this an element for development value. And that's perhaps where it's.
I mean, I find that. I mean, I understand. I mean, maybe there's no good meaning which can give to it at all. But I find your meaning rather difficult because if you sent a valuer along and said, "Please value this land on the open market," then he would go along and see that, and then he would say, "Of course, actually, I know there's a possibility of housing in some time in the definite future. I'll add that bit of hope value in, and I'll come up with a thing." He wouldn't need to be told. I mean, adding this our agricultural land wouldn't tell him anything, would it?
Well, if it tells him nothing, then again, my submission, it still leaves him with development value.
I know that's your position.
Yes. And it may be that's the view that the court takes of the words. But whether it does tell him something or it doesn't, my submission, he was entirely correct to have regard to the attribute of the land evident from the development plan. Not sure, unless there's anything else that I can assist with, that's really the submission for the council on why this has not been stripped out.
Yes. Well, thank you very much indeed, Mr. Muir. Mr. Finlay?
No, I've not.
Thank you. Mr. Gale?
Very briefly, if I may, on the matter of commercial space
Yeah.
arising out of this clause. Sir John Dyson has mentioned the price that was fixed for the first year, I mentioned that at the outset in setting context, that there was this price fixed for the first year. And it does seem to me that that is significant. The inference, I think it is correct to say a very clear inference, from that price is that was arrived at, having regard to the state of the land at the time, i.e. as undeveloped, but with the potential for development in a particular way.
But your averment is that it was actually in use. It's very strange you're saying that.
And that averment is, I think, put simply, my lord, nonsense.
It really
but I don't know how that averment is to be there. It simply isn't the case. I can confirm that on the basis that having been involved in the case since the matter was before the division, I have met with the client. It is clear that there was development that was not the existing law. Put in those two terms, to use that situation. But of course, it does. I think I used in my submission earlier that the approach which I urged upon the court and the construction of clause 18.2 which I urged does correspond to the situation that existed in the first year, so far as valuation is concerned. It is valuation of a particular of land in a particular state with the potential for a particular form of development. So that is effectively, my lords, the only point I would seek to emphasise in this file. Save to say that the lady made the point as to the fact that if this lease continued, then the benefit to the landlords would be the simple receipt of rent for the use of the golf course. That appears to be an accepted position. That appears to be a commercial decision. That is a commercial decision that the landlords took, and would tend to suggest that there was a degree of acceptance of that. Subject to that, unless there's anything else, I would be here to a solution on that.
Well, thank you, Mr. Gale. We're extremely grateful to Council for their assistance, both orally today and in writing. We will take time to consider our decision.